This
Town of Ocean
conference will now
Planning
be
and Zoning
recorded.
Meeting, February 18th, 2025. Roll call, please.
Member Black?
Who you calling?
You.
I'm not present. Here.
Member Baptiste?
Present.
Member Siggety?
Present.
Chair Khalil? I'm sorry, Vice Chair Khalil, and then Chair Ferber.
Here. Pledge of allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Amen.
Amen. Okay, we'd like to open up to public comment. If there's any. Jerry, nothing
I'm
today?
not on here, but some of the items I might comment on.
Okay. Okay, with hearing nothing, we'll close the public comment. Approval of the minutes from our January 21st meeting.
I had one,
I'll approve.
I had one comment.
Yeah.
I was not present, so I couldn't have seconded the motion to adjourn.
Correct, we will get that taken care of.
I approve the so amended.
All in favor?
Aye.
Aye. Okay. First on our agenda is the quasi judicial hearing on 7 through 9 Sable Island, the replat of it. At this time, any ex parte communication shall be disclosed by identifying the subject of the communication and the identity of the person, group, or entity with whom the communication took place, or any correspondence be provided to the town clerk and made part of the public record. In addition, each member of the commission may identify the existence of any investigations or site visits he or she has conducted, or any expert opinions received, and disclose any conflicts of interest on this matter. Each member?
None.
Mr. Chairman, I do walk by that lot every day, and I did do a visit just to inspect the seawall because we're considering some new technologies, but I haven't talked to anyone.
Okay. I met the owner there a few months back just to say hello to him. So I just, many months ago. So with that said, let's go ahead and let's proceed with this matter. Let's see. Town clerk, swearing anyone who'd like to give us testimony, please.
Will anyone wishing to speak on the item, please stand and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? When you are called forward, please state your name and address clearly for the record and whether or not you've been sworn in, and please speak directly into the microphone.
Kelly, thank you. Let's start with the town staff and Corey, please.
Good morning, Chair.
Town planner.
Good morning, Chair, Commissioners. Corey O'Gorman, Town Planner. This is a request for replat for lots 7, 8, and 9 of the McCormick Mile plat into 2 lots described as lots 1 and 2, the McCormick Mile replat number 1. As noted in the staff report, the replat exceeds the minimum requirements of the RSF zoning district, including reconfiguration of some drainage easements, and the recommendation from staff is for approval. This is pretty straightforward, at least from a staff perspective, and it does comply with all the requirements. The staff report outlines several of the code sections that are relevant, including the review by Planning and Zoning Commission, the RSF requirements, and the plat preparation section of the code. We're happy to answer any questions that we can, and once again, the recommendation is for approval. Thank you.
Any comments?
I just looked at the old plat with the 3 lots and noticed that they each had drainage easements. And lot one on the new plat of 2 lots has the drainage easement on the south. But is there one for the lot on the north, or is it interconnected to the lot on the south?
I would have to defer, I don't see the town engineer here, but my understanding is that there was discussion with the applicant regarding the need for, specific need for easements, and those are accommodated in the replat. So there wouldn't be a need for it on the other lot, is my understanding.
There was an extensive amount of work done there, and maybe we'll hear from the applicant about what actually was done there. The town engineer, is she coming today, do we know? Okay. Okay, any other questions? Zoning official, Manny, is there anything that from your perspective here?
None at all.
Okay, great, thank you very much. Hearing that applicant, please come forward and make your presentation.
Good morning.
Morning.
My name is Paul Engel. I'm with Engel Land Surveying. I'm the surveyor of record for this particular project. I'm here on behalf of Max and Rebecca Weinberg. Max is present with me today. And we're here to answer any technical questions that you might have. As far as the drainage, that has been, the old easements are going away, and the new easement along the south side, the pipes have been interconnected. And it's, to my knowledge, it has all been approved by the town engineer and everything's fine.
Okay, comments? Christie, does that show up on your world, the easements there?
It does, Mr. Chair, and I was actually just looking, there was, as I recall, and the applicant, correct me if I'm wrong, because I'm just going based on memory from last year, but as I recall, there was a town easement that was adjacent to the home that was there, but in replatting this, they wanted to move the easement to the edge of the property. So there was a town resolution that we did to allow them to remove the one easement. The town was agreeable to abandon it, and then the grant of a new easement to ensure there's proper drainage.
Okay, and
I just can't specifically address this because I don't recall the specifics, but I'm assuming that they match up.
And is that on the survey that we're looking at? Is that on this survey? The easement?
The survey
believe the
itself,
new-
no, but it would be shown on the plat.
Okay,
If you
Right,
look at, you see
so-
at the south end of the plat?
yes.
That would be the new easement.
Just for clarification, so you said that now both lots drain to the southern 10-foot easement? Is that?
That's the outfall pipe.
Yeah,
That's the outfall.
And that services lot 2 as well as lot 1?
Yeah, I believe there was a drainage pipe that was connected. They put a new structure in at the south side and connected it to the existing structures so it could collect everything and send it out.
And wouldn't there be an easement coming across lot 1 in favor of lot 2?
No, it's in the road right of way.
It's in the
which
road
is
right of-
public right of way
okay.
already.
Great, that helps me, thank you.
Can I just, I walk this area quite often at, when we get a heavy rain, there's some water that sits in this world, right? Has that been addressed at all?
That I can't tell you for sure. That's-
If I can.
Please come up, please.
Max Weinberg, owner, 813 Delmar Way, Delray Beach, Florida. Yes, it has been conclusively taken care of. The street will no longer flood. These are 18-inch state-of-the-art pipes. Everything from lot 6, which is north of lot 7, flows southward into 2 new catch basins, and then flows out with a non-reversible flat, I forget what you call it, so water won't back up.
Mhm.
It's 18 inches wide. The old one was not operational. There was one disconnected in 1975, which the former owner of 9 built over. That was disconnected. So the only one that was in the ground was on the border and the easement between, the setback between 7 and 6. That, when we finally dug it up, was completely non-operational. So the new drainage system will actually drain the entire street.
Great. Thank you. I noticed because you did an extensive amount of work, Mr. Weinberg, on your property, and I saw with the drainage, and it looked like they were doing, I just wasn't sure exactly what was going on.
Yeah, it's a lot of work. It's very efficient. We've had many tests on it. It's completely new. So if you remember last August, there was a lot of rain and the street
Yes.
retained a lot of water. That won't happen again. The addition of the new seawall, where the old one was 2 feet, this is 7.5 feet. So it should conclusively keep water off those lots.
Great, thank you. Any questions? Thank you very much. Okay. Any other comments here on our end, gentlemen? For public comment then? Let's open up the public comment, please.
Terry Brown, Hubbard, South. So obviously, the drawing disappeared. The goal is to build larger structures. I mean, there are a lot of large houses in this neighborhood, so that would fit in, as opposed to having 3 smaller lots. But the question is that, does any of this replatting affect setbacks? Side setbacks, front and back setbacks? Does it give them any kind of advantage to come in for a variance on any of the construction-related codes?
Good question. Corey, do you, still all the same, I would think all the same setbacks remain, don't they? The town code setbacks?
Yeah, and in terms of variances, since these are lots that well exceed the minimum requirements, my opinion, without seeing a specific variance, is that there wouldn't be anything that would represent special conditions or circumstances that would justify a variance. I would think that all of the new construction would have to comply with current town codes for setbacks and FAR, and would certainly have to come back before this board for development plan review.
So the town has obviously already calculated the size of the structures. They'll know what these houses look like in terms of bulk.
The maximum, I'm sure you can get what you're trying to ask, what the maximum is.
As long as everyone else knows that when they go up.
Yeah, right.
Thank you.
Well, the applicant at one point had presented a 1-story, very attractive 1-story structure.
That would be good.
Very, very beautiful structure. We had looked at some architectural renderings from 3 or 4 different locations, Hawaii, somewhere in Asia, and they were very, very nice. So yes. Okay. We'll close it. Any other internal comments, gentlemen?
No.
Right? No? Do we hear a motion?
So moved, approve as submitted.
I second.
Okay. All in favor?
Aye.
Okay, great. Thank you.
Congratulations.
Thank you very much. Yes. You've done a nice job. It looks beautiful. I walked by it this morning.
Thank you.
Okay. Next on the agenda, approval of the work restrictions for holidays. Neil, you seem to be very up to speed on this.
No, I would just, for anybody who's done construction and you have a limited amount of window,
Yeah.
anybody who's done construction has a limited amount of window to get work done. As we further restrict that window, I understand the concern about both traffic and outside noise. I think we should modify this at least to allow inside work on those now proposed additional holidays of Christmas Eve, New Year's Eve, and Easter, Good Friday.
Comments?
I'm tired of the noise around my community, to tell you the truth, so anything that mitigates that, I'm in favor of. It gets obnoxious. So before the holidays, I can go either way, but I think somebody put this together for a reason. Do we have a number of complaints? It's kind of what it reads.
I actually would like to hear the driving force behind it.
This was brought before the commission, their last meeting by one of the commissioners. We have had people commenting on, especially Christmas Eve, having company in, family coming in, and construction taking place on Christmas Eve. The amount of complaints, I can't tell you. I didn't write down a number of how many, but we have received some complaints and concerned commissioners.
Mr. Chairman, having gone through a number of the renovation, always the holidays tend to be end stops on them, and there's always that little mad rush to get things done before your own visitors arrive. So I have some issues with this.
Uh-huh. Uh-huh. Listen, I'm kind of somewhere in between myself personally. I mean, I think that there still has got to be a stop date for these kind of activities, right? And there really does. And I love what Neil said in terms of interior only. I find that it's just going back to Sable Island. I walk around the house at the end of Sable Island, the furthermost southern point. Those people have been working on the weekends, Saturdays, Sundays, holidays, whatever, right? They've, I went and spoke to them at one point. So I'm not sure even how well enforced this is, right? Do we have the ability to really enforce these timeframes? Who knows, right? But yeah, certainly interior where it's not making any noise, I'm okay with that. That would be, to me, acceptable, right? If you're painting, that's really what you're saying.
Carpet installation.
Carpet installation, painting, simple items, right?
I think that's what it says.
Right?
To cause any operation of any tools or equipment used in construction, drilling, repair, alteration, or demolition work, or perform any activities on the site related to construction, drilling, repair, blah, 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 demolition work. So I don't know if it's already covered for interior, but we could probably make it more specific.
Well, just if you had an inside contractor working and there was no work on that day and the police showed up, they would say no work on that day.
Yeah.
Just-
Police would never know.
You need to clarify.
If it's inside. Yeah.
But that's the
If
truck
it's
part.
inside.
The issue is the truck part.
If it's noisy, the neighbor calls the police. If it's not, they're not. So.
Ken, anything on your end as you're sitting out there? You want to join the meeting? Can we ask Ken to join the meeting? I don't know how this works, kind of. Kelly?
Yeah, I can join.
Yeah, please.
You're safe now.
Thank you. Yeah, one compromise is you make the day before the holiday like a Saturday. If you're really that bent on I have no problem doing it the day before. I understand it. I've had to live through that many times, and I can understand the frustration that some people have the day before a holiday, especially like a Christmas Eve or a day before Thanksgiving or whatever. I can certainly understand it. Anybody that had to live through the seawall across from us for the past year and a half, hearing the pounding would have a second thought about not having some restriction applied, especially on a Christmas Eve, because they were doing that. So one compromise, like I said, could be you just treat it like a Saturday. So it's done by noon.
That would be a reasonable compromise. Stop at 1 o'clock, I think, is the time for Saturday, which.
Mind you, I'm in favor of the entirety, but I'll be willing to compromise for the short term.
We keep going like this, we won't have any work days left.
Right, no, I understand.
How about leaf blowers?
Oh, those drive me, right, well.
Don't go there.
Every
Yeah.
single house on our canal does their lawn a different day. Every single one.
Palm Beach has a noise restriction on leaf blowers.
Yeah.
And
Didn't Gulfstream pass one too?
I don't know if they did or not.
Yeah.
But I would love for us to think about that.
Yeah.
Because talk about annoying, those annoy me at 8 o'clock in the morning when they're doing it. I mean, even if you're awake, they're annoying.
We're trying to have a Zoom call.
or anything. I
That's
mean,
just-
electric blowers here are great, but, anyway.
So shall we, can I hear,
I'll make a motion to
Yeah.
amend it to no later than 1 PM on the
Or same
eve
as-
of these particular holidays mentioned.
Or the same rules as a Saturday permit. If we change the Saturday permit, then this would change with it, so you don't have a
Yeah,
separate.
which is 1 o'clock.
Yeah, I second that.
all in favor?
Aye.
Okay, great.
Can I get some clarification real quick? Are you recommending that just for these additional ones, it's just till 1? Or across the board, we currently have where there's certain ones we cannot work on and treat all those the same?
No, I think, excuse me, the ones you can't work on, right, are the real holidays, Thanksgiving Day, Christmas Day,
Right.
Easter Day. You can't, those are still restricted, I would think, right?
I think the motion.
Yeah, yeah.
Yeah, absolutely.
Yeah,
Day
those are
before.
completely restricted.
Okay,
completely
so maybe-
restricted.
And most of the other holidays are on a Monday. So, other than the ones that vary, they're on a Monday. So you're really talking about Thanksgiving, Christmas, New Year.
Easter, no.
No, it's not. But those, the other ones are typically on a Monday. While were you in discussion
Yes,
or did it pass already?
I think we
Well, I
passed.
think the
She
clerk
was asking for
clarification, because in the ordinance itself, there are certain federal holidays that are identified. So are we saying the eve of all those certain federal holidays that are identified?
Yeah, my,
Because it's New Year's Day, Memorial Day,
Okay,
Independence
Independence
Day,
Day,
Labor
Labor
Day,
Day,
Thanksgiving Day, and
Christmas.
Christmas Day.
as listed, those days that are the eve of those holidays, no later than 1 PM is what
Is
I
that
to
what the second
articulate.
Is that everybody's,
That is my understanding.
Yes.
everybody agree with that?
Those are the varying holidays, I believe.
Yes.
Another comment though, Christie, when you go back, would you look at how this, because you're gonna take this to the commission with a rewritten version, correct?
Mm-hmm.
Would you look at the, how this is written, maybe clean it up? Because there's way too many commas. And, what happens is you can make an argument that, you could actually work on those days, the way this is written. So, I would rearrange how this is written just slightly. It's just awkward.
We'll look at, seeing if we can clean it up, to make
Yeah.
it clear that it's Saturday for limited time.
The intent is there, but
Sundays,
I think it's just,
no those holidays, and then for the eve of those holidays, only like a Saturday, no later than 1.
Good? Everyone good?
Good.
Okay, great. Staying with you, Christie, talk to us about your review of the proposed seawall ordinance, please.
Okay, yes, sir. Based on the discussion we had back in October, and we delayed this a couple meetings because of the year-based amendments we were doing for the comp plan. The proposed seawall ordinance does several things that we discussed. Obviously, it keeps the minimum height, remains at 5 feet in ABD 88. Then we had talked about allowing for, with the reconstruction rehabilitation, that you could add 18 inches out from the property line. So if you're building on to sort of the existing seawall to rehabilitate it, that would be possible. Which then kind of led into the whole seawall cap, because then you'd have to allow for accommodation potentially for that seawall cap to be further out than 18 inches if you're adding on to an existing seawall. And some of the ordinances I looked at, they had that 2 feet, some had it 3 feet, so I just left it at 2 feet. Then also addressing the interconnection between your dock and your new seawall, so I tried to address that. And then one of the issues seems to be the seawall that's built higher next to a property with a lower seawall, and making sure that you maintain your water on your property. So that was the return added there as well. So this was my attempt at sort of bringing all of our comments the last time we discussed this in October into an ordinance. One of the things I would like to mention is in the ordinance itself, there's a definition of reconstruction and rehabilitation. And we kind of got into this when we were talking about the amendments to the Florida Building Code and the flood management provisions. And right now, the definition that's in there for substantial repair or substantial rehabilitation mean if it's over 50% of the value, and it's specified more than 50% of the length of the property shoreline, or any modification or alteration of an existing seawall that exceeds 50% of the fair market replacement cost. What I didn't include, and one thing to maybe just consider, is we currently have that now 2-year look back regarding substantial improvement for other construction. This would allow someone to come in and essentially do 45% rehab to their seawall and come back 6 months or a year later and do another 50% or less and not have to, raise the height. So I didn't know if we wanted to include some type of look back. So that's just a thought.
It's interesting.
Yes.
Do you want to just address that one point first, or are you done? You want other
Anything,
points?
yeah.
Because I had 3 points. The first point is talking about substantial repair and improvement. I believe part of our discussion, and Shields, correct me if I'm wrong, was we want to get to the point where if they're substantially improving their property, the resident and everything else on there, that they have to do the seawall. Is that somewhere? I can't remember. Do we have that somewhere? So it's not only the substantial improvement of the seawall, but it's of the property as a whole.
To tie back it in.
To tie back in.
Because just to your point, we had an applicant that came came in they were taking an existing home, renovating and enlarging it, and they had no requirement, this is last year, to do anything to the seawall. I think, is that to your point?
No, I think that's what we have to address. I think at that point, it warrants, if they're putting up a new house, and I can think of some examples where there's going to be some homes that are going to be brought down, and I can imagine that the contractor's not going to want to do that, and that's going to be to the detriment to the town. So I think that has to be addressed.
So if they reach the threshold of substantial improvement of the primary structure on the property.
Correct.
I also think the idea of piecemeal doing a seawall is probably, from an engineering perspective, not cost effective anyway. I don't see too many people trying to, fix one half and then come back to the other half. It's just, these are interconnected structures that support each other. So I agree with Ken, and if we tie it back to the main structure on the property, that would work a lot better.
Okay.
Just kind of stepping back for a second, our goal is, right, with potential rising water levels, is to make sure the town is protected, right? Because we're a town of seawalls. Really, we are, right? That we have nothing but, in the west side of our town, is nothing but a series of seawalls that's their only, defense against rising water levels. I think, Christy, do you view what you're talking about here kind of looks at this as a global, okay, we've got to have a vision to take what's in place today, try to improve what's in place today. When everyone, does substantial work to their home or builds a new home, they have to put a new seawall in, etc. Is that in the body of this?
No, and I think to Commissioner Khalil's point, it's a good tie-in because obviously with having the threshold for substantial improvement dealing with your primary structure, the ideal is the non-conforming structures start to go away because now you've got to bring everything up to code. So it would make sense to tie it into the seawall so that we are not just protecting folks' structure from flood and those types of things, but also the seawalls.
Okay, because we kind of looked at, you and I looked at the Fort Lauderdale, what they did down there, which they had like 3 pieces to that, didn't they? Like if it's in disrepair, it needs to be repaired and brought to a new level, right? Certainly if there was a new building going on, a new structure renovation or new building, that seawall of it. And then I think the third link was too, if you are the weak link amongst the seawalls, that you have to find a way to bring the seawall up to be in compliance with this code to, again, give everyone in the community the protection that they should have at the end of the day. And I remember we looked at that. I don't know if I've got that with me, but they kind of went through a comprehensive look. They got a different story. I think they're very low there, but still, we've got areas that are low as well. And listen, I'm seeing the new landowners, the applicant here today, he substantially completed a seawall. On Sable Island, there's looks like a house raisure going on to Sable Island as well on the left-hand side of that lot. They've raised their seawall. Ken, you had to live through the seawall over at the Maisonettes. That's, substantially complete. It's complete, at the new level. I'm just wondering I don't want to force the issue, and I talked to one of the commissioners, and some people were asking the question, yes, we think that's a great idea, but I can't afford to pay for it. So but still, how do you balance that out versus you have to protect the community as a whole? How do you protect the community?
You're raising a very good point. And I'm trying to think how, and I'll liken that to the Hurricane Sandy. When Sandy hit Manalapan and that coastline, and the zip occurrence took place along the seawalls.
Yes.
And the DEP granted emergency variances for everybody and said, just go to work. It was an automatic permit, no issue necessary. But the biggest point there, and that carried on to Anna Street, the seawalls down there, is that you had some weak links that then counteracts the other good seawalls. So it is something I think maybe not addressed today in this,
yes,
but I think it is something that we need to address. So that might be a topic for another day. But we should address it. I agree with you, Shields. I think, and the town as a whole will have to think outside the box and think about what the town could do if there is such a situation where there's an affordability issue, because that is a health, safety, and welfare for the community as a whole. We'll have to think about that. But going back to the substantial improvement, I think it should tie in so that we're consistent in how we define things. It should be defined in the same manner that we do the other. So if we do have whatever, I can't remember, I didn't think it was a full 2 years, but whatever it was, maybe it was, just don't remember. Whatever that is, it should be consistent. So this way, our staff isn't trying to play with 2 different definitions. So at least the timing of it is consistent. So that would be my recommendation there. You want to hear my other points? The second, I just have a question. You define in subparagraph 5 a wall return of the same material shall provide a wall return. That is probably a term of art. I just want to make sure of it because I think I know what it is. But are we comfortable with that definition of wall return, that we know what it is? Okay.
I actually have a comment on that. I think to refer, it has to be the same material as the CCAP. I'm not sure that there aren't new technologies coming on for the seawall, for the cap that aren't suitable for a return. I mean, obviously the return, most designs will have a return, because if you don't, you're gonna undermine your own seawall. You have to bring it up on the other side, but I'm not sure, if they decide to do some cladding or something on the main seawall cap. I'm not sure if that restriction is necessary.
You're the engineer, I'll defer.
And as you
You have
point out,
more
you went and
knowledge.
saw our applicant's seawall. He did it, he didn't use concrete, right? He used a plastic material.
Yeah, a lot of the seawall material is PVC now.
PVC,
Yeah, which has a longer lifespan, more resistant, all that. But on the return side, you need something a little bit more structural.
Yeah,
Well,
on
the
the
cap
ends.
would still be concrete.
Well, not necessarily. That's an option, but I can see it evolving into a little bit more of a kind of a more holistic system. It's coming around the bend, so I'm not sure we should restrict it.
Okay.
So could we say something like, other engineer-approved material?
Yeah.
I had a question. Those of us live on a narrow canal. It doesn't say that you can repair your seawall and get an additional 18 inches only one time from the property line. Or is that definition, an additional 18 inches, mean a one-time expansion beyond your property line?
That would be an expensive continuation of 18 inches, that's all I gotta say.
But are you concerned about every 25, 30 years, somebody wanting, and so it keeps creeping into the,
I mean, you got a point, but, no. And after 200, 300 years.
But it's a
who
lot
knows
cheaper to
what
add that
will
18 inches in front than it is to tear your seawall out and put it in correctly.
I would suggest we follow the Army Corps of Engineers, whatever language they use, because that's where this
They
18
have that
inches.
in- that-
Yeah,
that
that's
is
where
where
it
it came
originated.
So a one-time 18 inches.
I don't know if
I
that
think it
reg
is.
says one time, but it limits it from the 18 inches
So the
from.
property line never changes. Your seawall is
I don't remember.
into the
how
right
it
of
says.
way.
Anybody, you guys know what it says?
if you
I don't
resurvey, the
remember.
property line doesn't change, does it? You have your
No.
seawall going up?
The
No.
idea was to allow you to build a new seawall without having to
Tear down
demolish
the
your entire seawall.
Because it gives
Existing
support.
one.
Right.
So you take the batter piles out if they exist, you build a new one in front of it. And I believe it's a one-time only, but I suggest we follow whatever.
Yeah, it would make sense.
And then also in there, we have three definitions: property line, which is clear, water face, and waterside edge. And they don't seem to be defined. Wet face and waterside edge. Well, they have three different terms.
Water face is a term of art, which is where the water meets the
Seawall,
face of the seawall.
which is not your property line.
That is not your property line.
Right.
The outermost water edge is the sea cap, which tends to extend beyond the face of
Like
the.
2 feet.
Yeah, there's also the issue of batter piles and the extension, because they come at an angle, so we'll talk about that in a little bit, but just,
Okay.
those are, well,
Defined terms
yeah,
elsewhere,
yeah,
not in
that's
this.
correct.
Okay, that was my question, because it wasn't in this.
Christie, you've worked, now just looking at my notes, you've worked on this before, haven't you? This,
Correct.
Okay.
And granted, I'm working on this as an attorney. So when you look at like what Fort Lauderdale did, it gets very involved and very
Very
in-depth.
technical.
So very technical. So if you want to go more of a very technical route, then we need to get our engineer folks more involved and perhaps a consultant, because these can get very technical very quickly. And I think initially it was just, let's just do the 5-foot minimum. And now we've started talking about all these other issues. So it sort of starts to get outside my comfort zone and drafting something that's becoming more technical.
Yeah, I can understand that.
Yes.
Definitely.
Yeah.
But, I mean, we'll handle this today and then put on the agenda at some point that I think we should tackle it.
Yes.
I think that's a fair way of dealing with it.
Yeah.
In my last point, what a perfect segue to it, because talking about property lines and wet face and all that stuff, which are terms of art. And that is in subparagraph 2, Christie, where it says seawall shall not be constructed beyond the property line adjacent to the waterway. So as we know, waterway defined has varying meanings that people want to employ. And And so I thought about, okay, how do we fix it? It might be as simple as adding the same language that you have in the next sentence at the end, so not unreasonably interfere with navigation of the abutting waterway. The reason why I say that is because we were successful there's a case called Travis, and we were successful that the property line is now extended to halfway in the waterway when that case arises. So, situation arises, I should say. So we should put something in there that limits that waterway definition, because the property line does extend into the waterway by virtue of that. So.
When you have the cap, you're trying to say.
Well, this is the seawall shall
Shall.
not be constructed beyond the property line adjacent to the waterway. So somebody could make an argument that they could pull that seawall all the way out to the middle of the waterway.
Yes.
Unless we have something in there that has some other mechanism. I'm trying to avoid somebody taking a really crazy look at, view towards it. And I know somebody that could. So I think there has to be some limitation there. Those are my 3 comments. Extended.
Mr. Chairman, I have a couple of comments.
Yeah, please. Any further comments?
Yeah, bullet item 3, the extending 2 feet beyond the wet phase. Again, I want us to keep in mind that there's some of these seawalls have batter piles, which sit at an angle, and you will not be able to use the water if you have to clear that in order for any vessel to be able to.
But your dock would go out
Yeah.
5 feet, so your dock would be beyond your batter.
So is the dock beyond the sea cap?
Yes.
That's fine.
Is it 5 feet from the property line or 5 feet from the end of the sea cap? I can't remember.
It's limited from the wet phase.
So it doesn't say, it really doesn't talk about the batter piling. It's just the cap.
Right. The batter piles extend out, so that's
They
the
extend at
problem.
least 3 feet.
Yeah, so that the issue is the access. Then,
But that doesn't address the batter pile. It's just the seawall cap.
okay, and again, if the understanding is 5 foot from the outermost water side edge, that includes the batter pile, then I'm okay with it. If it does not, then you might have some issues. You just have to clear it.
I don't think, the cap is not a batter piling, so.
No, I'm talking about item 4 now.
Oh, item 4,
I'm sorry. I'm clear on 3. On 4, where the dock is 5 foot out from.
So it would cover the 3 feet of batter pilings by 2 feet, right? For the dock.
That's usually what happens.
Right.
Yeah, that's typical.
I'm trying to think of anywhere where I've
It's
seen
like
a
a-
batter
yeah.
pile
But in
go that
case
far
of
out.
like a floating dock, not a dock,
Foot.
that's.
If floating deck, you have a problem.
Yeah, so the issue is, as you raise the seawall, unless you put unless you put a lift, you're
Yeah.
gonna end up with a floating dock. And that floating dock, has to extend 5 feet from the batter pile at the water level. Or sometimes they use riprap to just shore up the seawall. You have to move from that. So I don't know if we wanna keep that as an exception all the time, or just,
It does kind of eliminate floating docks.
which is, as you raise the seawall, they're gonna become more and more common, because it's, you cannot.
If you have the batter piles.
Yeah, but given the soil conditions, I speak with some expertise on this, going through this, it's nearly impossible to use the tieback situation. There are 2 ways. You can run tieback into the soil behind it, like helicoils that hold the seawall, or batter piles on the outside. And a lot of the soil along the coast here is just, there's no holding power to it. So that's why you see batter piles more often than not.
Yeah, I think you're raising some really good points, and I think what we probably should do is, if we're in agreement, recommend the change here and then go back and have engineering examine that aspect of it, because you're right. And as the cap is going, as the seawall is going higher, the batter piling is going further out.
Right.
So I guess we do need to get some engineering viewpoint on that.
And the outside of large lifts for large boats, the small watercrafts you really need a floating dock to be able to get on a stand-up board or any of that stuff. So they are going to become more and more common as the seawall spreads.
And we do have that safeguard that says as long as it doesn't unreasonably interfere with the
Right.
navigation of
Yeah.
the budding waterway.
Yeah.
So we have that,
Yeah.
the staff can play with that and make that determination a little bit. So there is a little bit of judgment call there. Yeah, those are good points.
Lynn, how would you approach this relative to a kind of consultant engineer specific to this field? Do we have someone that you've consulted with in the past?
I don't believe this is a specialty area that Ingenuity has, but we can speak to them, see if they have a recommendation, and if they don't, then we can talk to other coastal communities, see who they have used to help them with their seawall ordinances,
Yes.
and find someone in that way, perhaps bring 3 back for the commission to make a decision on who they want to hire in assisting us with this.
And those are good, that's a good point. I think, P&Zs historically have sought the community out, whether it be architectural or others. I wouldn't mind hearing from a contractor, a seawall contractor, to get their viewpoint, and hear how this functionally works. And maybe we can ask one of the contractors to come in and kind of give us a little
Lesson.
yeah, if you will. I think this is all functional.
Did
This
you
is
get
a
to know the guy
practical-
across the canal pretty well?
Yeah.
For the 18 months, maybe?
Yeah,
Maybe
right.
give us, give him a call.
Yeah, right.
You guys are pen pals.
Yeah.
But I know, we're fortunate.
Yeah.
We have a few really good seawall contractors in town here
Yeah.
that are working. So we should approach them.
You're the
Get-
applicant's
get
contractor that you
different-
mentioned, you talked.
B&M does a lot, APH. So there's lots of them.
Yeah.
We could, I think
No
we should.
no shortage of.
Yeah,
Yeah.
I think
People
we
who
should,
can come
and
in.
I really believe they would be more than happy to volunteer their time to come in to do this.
It saves them a lot of battles down.
It does.
Down-
No,
down the road.
and they love talking about it, so.
And it could give them work going forward here, right?
That's not the issue, but
Yes.
yeah.
Of course, yeah. Okay, so how do we want to wrap this up?
Public comment?
Oh, excuse me.
No.
No. Terry, public comment.
Terry Brown, Harvard ISCOC. I'm assuming with so many experts here that you can answer these real quickly, but since these are public waterways, so the language in this new ordinance or code or whatever it's going to be, we're assuming that DEP and everybody else approves of that situation when the homeowner applies for a permit. They're going to say, well, see, it says right here, 5 feet. And they're going to say, okay. So I don't know how that works because they are public waterways, as Ken knows, even though we had some lawsuits regarding where that began and ended. Remember the
Yeah,
guy-
so interesting. You're making a interesting point here, and this is where.
All right.
Yeah, this is where it gets complicated somewhat. When you use the term public waterway,
That's what the code is.
but I understand that, but that's partially true and partially not true.
Yeah, I know, there was some cases.
So there might be when you use that term, there is waterway access as opposed to public waterway.
Right.
It's not owned by the town. So some of it's private, but accessible by the public. So that's not considered a public waterway.
Some of the PUD, I guess some of the, like the developments that dug out their own channel.
Ocean Harbor.
Yeah. Pelican Cove.
Sable behind Sable. I mean, that's where this Travis case comes in, and I think, so that we don't throw Christie on the spot, I mean, it takes a little bit more examination, but
And
in
another
answer to your
language
question,
says interfere with navigation.
Yeah.
So
Right.
I'm not
So to
gonna-
answer your question, as it relates to fine and DEP and Army Corps, since DEP speaks for Army Corps in relation to this, it depends upon whether they're asserting jurisdiction to make those determinations.
The other comment I wanted to make is that your earlier comment, that if a structure was torn down and it was substantial improvement, does it include having to replace the seawall? You're saying yes, that it should be. My question is that, and we know this has occurred in Ocean Ridge where the seawall has extended out beyond the property line previously, either who knows what code it was they were looking at the time. So would that mean that a new owner of that property, because you're assuming someone's coming in and building a new structure, would have to move their seawall back away from the waterway to match the code that you're talking about in terms of extending?
That goes with this 18 inches that he was talking about. I mean,
Yes.
you keep adding on to the 18 inches.
That's right.
And so I think
Yeah.
it warrants what Fadi said, go back, let's see how Army, since the origin of that 18 inches, and he's right, does come from the Army Corps.
Right.
That gives a 18-inch variance, automatic variance. So, and the purpose of that, they didn't want to get stuck in,
Well, Mike,
No pun intended.
talking about cost, you'd have to pull out the old steel piling, right? The sheet piling. I mean, you're talking big money.
Well, the steel is cheap, it's the concrete that's
Yeah, yeah.
expensive. We have
Well, the
jackhammer.
labor, the equipment,
Yeah,
everything.
it's a very expensive proposition. I think the Army Corps did it to allow you to just build a new one in front of it. But I don't think, I do believe, and again, we should double check that, it is a one-time exemption, just to allow people to.
So in that case, the property line where the steel sheet piling is, or wherever the edge of the seawall would be grandfathered in.
So if it had been moved out over the years by
Yeah, I think
for some reason whatsoever, it went out 18 inches and now you're talking about another 18 inches.
Exactly.
Are you going to ask the new property owner to move it back to where it should be?
The property line, right?
That's right, the property line.
And then we know some of those are not always accurate.
this is,
Mine has a
Sometimes it's
footer
just enough
in
to-
front of the seawall. Is the
Exactly.
footer part of the seawall? Is that?
Yeah, that's a wet face.
so when.
So that's why we have variances, right?
So, that's another interesting point, because when a lot of these homes were built back in the 50s and 60s, right? Their lines weren't exactly perfect when it came to,
The only other comment I had was, in some
Old
situations,
seawall,
we have homes on the intercoast that do not have seawall.
Piling.
We have one in our own neighborhood at the end of.
oh, yeah, you do.
So would they be required to put in a new seawall at some point? Or just leave it beach-like is what it is?
Can I answer that? Because I did find, Christie, the one from Fort Lauderdale, the 3 criterias. One of those being seawall so low that tidal flooding breaches the seawall and sends water into neighboring yards and neighboring roadways.
Right, well, this.
Right? That was a criteria that they had, so that if, in that case, if it doesn't water into the neighboring yards or the roadways, that's fine. But if it does, you'd have to put a seawall on.
Yeah.
And I'd like to see that kind of concept included in here, guys, because I think that is part of this as well. I mean, getting back to the bigger view here, and thank you, that's a good question about your.
And anybody who was buying a piece of property, they would, I would hope, see it. I came to look at our property at high tide. I wanted to see if this was the street dry, they would look and know that there was an issue.
Yeah, that, whatever that's written, once we find out.
Seawall so low that tidal flooding breaches the seawall and sends water into neighboring yards and neighboring roadways.
Yeah.
Right?
Okay.
In addition to the other criteria that you've put in here.
So for the time being, can we correct, at least so that they have something moving forward past something, and then go back and re-examine the technical engineering issues at another time? Or do you want to hold off on everything?
I think we
until
should
such
hold off
time?
anything. We should ask Chrissy to make some changes to this. My suggestion is, let's look at that And let's ask, I liked your comment about ask Lynn to reach out to some contractors or engineers, if you wouldn't mind. And let's tackle it,
One time.
let's tackle it one time so we can give the commission, listen, Mayor Pugh, I was at the previous meeting and he was talking to us. His directive is, I want you guys to do as much on this as possible and hand it to us, right? So we know that you've really worked through it. And so I think that's what we should do.
Mr. Chairman, I think the wall issues are, I'm pretty comfortable that we have.
Okay.
But it's the docks and all that. And I think I agree that a second opinion or an expert opinion here will help us figure out the nuances.
That's a different,
Yeah.
would that be in a different code section, Christie, to your knowledge? This is
Docks.
minimum design requirements for seawalls.
Yeah, I'm sorry. The reference in subparagraph A4, 6477 is where you talk about the docks. So it is another section where you get into the specifics about what's allowed for docks.
Yes, sir.
I think I agree in part with what you're saying, but I think we could pass something here, or at least bring back the changes. For the
Yes,
next
that's what I'm
meeting,
saying. Yeah, let's
right?
wait. So let's
And we
get the
may
change.
not have everything done for technical, but we could at least probably address this section.
Yes,
Because I think what you're talking about and what we're all talking about may have to be a different section. But at least we can get this on the books to get it going.
well, let's look at that. That might be a good idea, have Christie redraft it.
Yeah.
And incorporate our comments, but still, let's research,
Yeah.
have
I
Lynn
mean, and if
research
you
it.
can get it done and get it incorporated, great.
Yeah.
Do it.
Just,
For the next meeting, right? Christie, are you okay with doing that for the next meeting? Okay, great. Does that make sense? Yep.
I have a question, Mr. Chairman. And item 5, where the elevation is greater than the adjacent property, shall provide a wall return the same material and type as the seawall cap. So that return is to prevent water going to the neighbor that's at a lower elevation. Is that the idea?
No, it's to prevent the backing, the
Yeah,
damage
it's
to
actually
your
for
own
your own
seawall.
protection.
Yeah.
So-
Because the water will come in from the neighbor to you.
And undermine
push it
Undermine,
out.
yeah, it's standard.
And we're having that today. We're seeing some of that today. Yes.
Yeah, you'd be crazy to redo your seawall and not protect the side of it.
Yeah, I agree.
So we're
the change
comfortable
there,
with the term. I think what he's saying from what I asked before, are we comfortable with that term of art? Is that wall return easily recognizable that we know what that?
I believe so.
He knows what it is.
Corey?
I mean, you guys are the ones that are enforcing it. Are you comfortable with this?
I understand it,
Okay. All right. Good enough.
for what that's worth.
We had two people that understand it.
Good luck, Christie. Moving on, the consideration of fee schedule changes. Lynn, talk to us about this.
Sure. As we're going through some of the online things, we are noticing different things. We also haven't done a lot of changes to the fee schedule. We've noticed in the past few years that when people apply for a variance to one section of the code, they sometimes, actually more frequently, end up requesting a variance to multiple sections of the code. Each of those should be considered a separate variance, but because we have always just said variance, we've only charged them the one fee. One of the things we're asking is if they're requesting a variance to multiple sections of the code, the first one would be $1,500 and additional sections of the code would be an additional $500. That's that suggestion. Looking at adjacent communities, Manalapan, Gulfstream, Highland Beach, DeQuesta, I looked at several of their current codes. There is a fee on, if somebody fails to request their final inspection before the permit expires, rather than just paying the $50 renewal fee, it would become a $100 renewal fee because they failed to do what they were required before the permit expired. This is something we run into quite frequently with permits for smaller items or permits that were issued and started on and then begin having changes, different things like that. Also changed the fee to $100 at the building official's discretion for the reinstatement of a fee, so, or of a permit. So if it's expired, if the building official thinks that they did it, just totally blew it off, didn't pay attention to when the permit was set to expire, they would pay a $100 fee, and then inspections for that would be $100. We've also had several permits that were submitted that were just for driveway improvements, whether it's replacing the surface, regrading, different things like that. Right now, those go through the full building permit process, which doesn't really need a lot of the building inspectors and building officials' input because it's a driveway, it goes to engineering. If we separate that off on a separate permit, if somebody's coming in just to do changes to their driveway, it would just go to engineering and planning, and that way the building official wouldn't have to be involved. See, a lot line amendment with 2 existing parcels. We've been starting to see more of that as people are buying older adjacent properties and seeking not to do so much as a replat like we saw today with 3 parcels, but with 2. And so if you want to amend your lot lines, it would be a $250 fee. Makes it simpler and easier rather than going through the replat process if it's only 2 lots. The land clearing plan review, we do not have that currently. And we have run into some challenges with that because without planning and engineering reviewing the land clearing plans, oftentimes we run into challenges where the applicant is not aware of the requirements before the permit can be closed out, including the final inspections. So if we would set that up as a review that was required if you're asking for a land clear and fill permit. Lastly, we don't have a fee for the portable storage units that we allow. The code currently allows administrative approval for up to 2 weeks. It is required that you submit it, and it does take administrative time as well as other things internally. So asking to consider making that a $25 fee. We also don't have a permit that is just for floating vessel platforms. It's seawalls, decks, and boat lifts. So creating a floating vessel platform, even if we meshed it with the existing of the seawalls, decks, and lifts, that it's something that people could readily understand which application that they need.
Got it? And then you go into the second, you've got floating vessel platform, application review, unit title.
Yeah.
Damage bond, demolition, these where there's no fees? Oh, is that where you've got those?
Right now there are no fees, and I'm just asking to determine whether this is something that we want to do. And if so, then P&Z would make recommendations of the fees. Right now we don't have a fee or a specific application for someone to do unity of title. And what some other communities do have that we don't have is for clear and fill permits where they're not doing demolition, a damage bond. One of the challenges we all saw on Hudson Avenue recently was there was a clear and fill permit. There was significant issues with the rain washing things out into the street, potentially damaging adjacent properties, getting the property owner to complete the permit within the required standards of the town. If we had a damage bond or something of those lines attached, if necessary, the town could go out and fix those issues without having to keep beating our head against the wall, trying to get the actual property owner or the developer to do it.
Got it.
Again, these are all things that I, saw in viewing other communities here in Palm Beach County's fee schedules.
So when, and looking at your memo here, so the numbers, you're not suggesting $25 for the floating vessel, floating application review, unity of title, those are just blanks.
Those are blanks. Those
So
would be if you
for us
guys.
to consider what those fees would be.
Correct.
Okay, so everywhere there's a blank, those are fees to be considered.
Right.
Okay,
And if there is two sets of numbers, the first is what our current fee is, and the second is what the recommendation is.
well, there's only one.
That's up at the variance.
Yeah, variance. So, you try to liken the fee relative to the involvement. I think actually we have that obligation to look at that aspect, not to the low side, but not to the high side, but, make it reasonable. So somebody comes in for a variance, and so they cite 3 code sections. That's going to cost them $2,500.
Correct.
And so in your viewpoint and that of maybe Christie and the planner, that's warranted by having those other sections mentioned. It's warrants another $500
Per section.
per section.
That is, and as I stated, that is what other communities do. It does require additional work because in addition to the first code section, the planner and the attorney have to go through and review the additional code sections, whether they're relevant to the first code section, how does a variance on the additional code sections impact the variance on the original code section. So there is additional time on a variance application that goes in when they're requesting a variance on more than one section.
So I'm adding 5 feet. Let me give you the example. So I'm just trying to understand in some ways. And I'm adding 5 feet, arbitrary. I'm making this up. I'm adding 5 feet, and that affects 3 codes. Is that considered 1 variance or 3 variances?
Currently, it's considered 1 variance, but technically it's 3 variances because you're requesting a variance on 3 different sections of the code.
I can understand it if I make the application for that 5 feet and also make an application on a separate part of the house or property for some other variance unrelated. Okay. But for the same matter, I think that's a little overreach.
And that's why we're here discussing it.
If it's all part of the same application, you're saying.
If it's part of the same application.
Right.
I just think that's a little bit of an overreach. If you're just,
So I think one of the scenarios that we're trying to address here is we get a variance to put an awning on a rear of the property, and they needed a variance from the rear setback. So that was 1 variance. Well, in order to tie the awning into the rear of the house, they had to then get a variance from the limitation on your rear outdoor patio thing. So there was 2 variants. So I think what the distinction you're making is that in that case, there's really 2 separate variants because Corey and zoning official had to look specifically at, okay, they're extending their balcony, that's 1 variance, and then extending out into the rear setback, that's your second. But it was really to do one thing, was to install this awning in the back of the house. There were 2 separate variances.
So in that case, I would advocate for one fee and not multiple fees for that one item. If they were adding on to another part of the house or another part of the property that required a separate independent variance, I just think some of that's that's a nickel and dime. Oh, you want this? Oh, you need this? Oh, now we're gonna add this, and it's like, okay, come on.
Don't prosecutors do that by, picking one offense and turning the
Don't
17?
blame the lawyers for everything. Don't blame
Oh, you
us for
opened your
everything.
checkbook. Okay, that's an offense.
So, in your
Seems
example, I would say that's one variance.
Yeah.
I mean, I would say one variance application.
So.
It's citing the two different codes because it's impacting two different codes, but.
It's one matter. It's one.
It's one matter.
Yeah, I get it. I
Right.
understand what you're saying.
So, yeah, so in the other way some towns and cities do this is they'll charge a flat application fee that's really supposed to address sort of your town staff time and effort that they have to put into administratively processing, like for a variance, taking it to a hearing, obviously. And what they'll do is they'll put a provision in there that says, this does not include consultants' time. And then they'll do a direct chargeback for consultants' time spent on each
Yeah.
matter.
Yeah.
There's pros and cons to doing it those different ways. One way is if, as been proposed here, if you just do a straight fee, then as the applicant knows, you know specifically what it's gonna be. But if it's something that, both Corey and I have got to take a look at and try to figure out how this works in our code and how the code works on it, sometimes that can take more. And so then you end up paying more than what the flat fee is. So you got to kind of figure out which one is the better method for
Yeah.
Ocean Ridge.
And that's a good point. At the same time, I balance that with the function of government. And that's why people are paying taxes. So part of that is the function of government. So some of that review, is.
Yeah.
So I've seen that, what you're talking about. I've seen and experienced that. It get to be a little crazy at times, especially when you're dealing with adding attorney's fees or engineering fees, especially. Mostly, I've seen it with engineering fees.
You usually got to post,
Yeah.
put the money.
After
You got to put something in a.
But some of these
yes.
things are, I'm thinking, I could understand if it's a big complex or big development, I can,
I asked a couple questions.
Yeah.
So the $1,500 fee, how long has that been established?
I don't know how long it's been that way for more than the time that the clerk and I have been here, and it looks like longer than the attorney has been.
So how long has that been?
The clerk and I have been here both about 2.5 years, the attorney.
So for a couple of years, we know of.
Yes.
And then how many times when you look at a variance change, do you get into multiple variances?
For one matter.
Yeah.
Oftentimes, it is a virtue of staff doing the initial review and seeing, oh, you want to do this. Well, when you do that, then it's going to result in you also having to get a variance from this section.
So it's more times than not.
Yes.
Okay. And when you compare other municipalities throughout the counties, variance fee, what were the ranges? Do we have them?
I didn't bring them with me, I can pull them up. But their variances were very similar to ours in cost for the start, and the additional fee is what I took from other communities.
Well, if we're in the ballpark there, why don't we just make it $2,000 and be done with it? And it's a matter versus all the different variances. And you're not gonna wanna have all the accounting for having additional charges for outside professionals and staff. That would probably cost a lot too, just internally, right? So would the compromise be if it's gonna be at least more than one variance for every application, that you just go ahead and come up with one little higher flat fee and that covers it all as opposed to the 1,500?
if that is how the planning.
I'm just throwing it out.
Simplified.
It
Well,
simplifies
well,
it.
here's the thing, here's the rub with that.
I think we're kind of like beating this horse pretty hard.
Yeah,
So,
but here's the rub. Somebody wants to put in a awning, right? That's a relatively simple thing. And they need a variance to put in the awning. We're gonna charge them $2,000 to do that.
We're charging
When the
$1,500
awning
already.
isn't, $2,000.
Well,
I
is
mean, I just have a hard
$1,500 too
time with
much?
it.
Or
That
is
seems
it
to
enough?
be-
Is it
I think
enough?
so.
I think
Is
1,500
it enough?
seems too high to me.
Yeah, I think
I
so.
mean, yeah, so we're basing it on, a survey of other
Yeah,
municipalities.
so maybe,
right? So-
this goes back to
And they
this.
have additional charges, and we're saying we don't want to have additional charges, so I just. made that aside.
No, I think this is all good, and I mean, this is what we're here to do, and in the future, talk about some of this stuff, is that some of the things that we're requiring a variance for don't necessarily need to go through the process of a variance board, that things can be done administratively.
Right.
And therefore, you don't have to spend $2,000 or $1,500 for something that's a relatively small, minor matter.
So should
And
we have
that's-
two different categories, an administrative variance?
I think we should. I
We
think
currently
need to look
have
at that.
administrative variance.
Okay,
And how much is
is
that?
that?
I believe the administrative variance is the same amount. I'd have to pull up our fee schedule.
Well, we make
I do-
$500 for administrative variance and,
But things are limited of what can go under an administrative variance.
yeah, I mean,
Okay.
so let's just get rid of all this fee schedule and move on.
Well,
We're getting nowhere on this.
No, you know what I'm gonna suggest? I'm gonna punt it back. So with respect to those blanks that you left blank?
Yep.
I want recommendation, I wanna see a
Yep.
recommendation.
I was thinking that as well. Tell us what you think.
Recommended amount.
Okay.
The second thing I'd like to see is, given the fact of a minor variance, how do we deal with that?
And add
And
administrative.
administrative variance
Yeah.
for things that don't require the staff time and staff need to go through this ridiculous stuff. Because I've seen that throughout, people complaining about it. And so we don't, I hate nickel and diming people.
The only reason somebody would have a portable storage unit is because they're doing a renovation, correct?
Not
Or,
necessarily.
but no, well,
They
it could
could be
be, but
moving in,
moving.
they could be moving out.
We're gonna
They
charge
could-
them a $25 fee for getting the pod while they move out, like an exit tax.
Think of the money.
Or entrance tax, imagine?
I mean, it just
Welcome to
sounds-
the neighborhood.
It doesn't
Yeah,
sound
with all those
friendly,
pods, our individual real estate taxes are going to go down, all those fees, I
but
think. It was subsidized.
portable, the land clearing plan review, didn't we charge them a fee for the permit to clear their land? Wasn't there a permit to get that? It's
Yeah,
only for the land
demolition.
clearing that there's an additional $50?
And that's for the review.
So it's that little nickel
Yeah,
dime
there's no
stuff.
Yeah.
building,
You
there's
don't
no
build
building
that
permit
stuff.
for land clearing.
There's no building permit.
There's no building permit.
There's no
There's
application
a
fee.
process where our administrative official signs off on a permit, it's more of a development permit, but it's not a building permit.
But a permit is coming.
Yes,
You're only clearing your land because you're getting ready to build a house.
ideally.
Ideally.
When you say clear land, you're not talking about demolition. You're talking about what? Removing some trees?
We're talking about removing trees, regrading the property, different things like that. And it's primarily when we get a lot clear or fill permit without them also submitting and starting the land development review process. That is where we're running into challenges. Somebody comes in and they buy one of the few remaining vacant lots, or they get permission to remove mangroves and things like that from the DEP. And so they start clearing and filling in a lot and have not submitted any kind of application or drawings or anything for the land development review process for what's gonna go on there.
Our applicant this morning did that, right? They filled the lot.
They did fill a lot.
Absolutely, they filled the lot.
We're gonna get a big fee when they file for these houses.
Yeah,
I assume-
sooner or later.
I think actually for Sable Island, they had to get a demolition permit because there was a
Of
house.
houses,
there was
yes.
a house there,
Yeah.
so they did actually a demolition permit.
And a fill
Not-
permit. And they must have gotten some because they put a lot of fill there.
They did.
I think as part of their demolition permit.
There's actually an application for the lot clearing.
Oh, yeah.
It's $300. So they have to get
Can-
that in
can-
conjunction with their demo.
I'd like to think that we could move on from this. I'd like what you said. Lynn, can you kind of clean this up a little bit? Give us an idea.
Can I ask a question?
Sure.
I just want to,
Name and
Yeah.
yeah.
Polly Joe, 35 Hersey Drive, former Board of Adjustment member. So I've dealt with variances. And I have one comment on the $1,500. It has been for a long time, like when I was on Board of Adjustment also, just so for the past 10 years, I'd say at least. But the $1,500 is the town. The applicant spends a great deal more than that preparing to come to this meeting, and I think that should enter into consideration. I have a question of clarification on the definition of section, and I just want to make sure I understand. If I look at this ordinance that was in our packet, and there's the section 64.2
Well, wait,
RMM.
please, what are you, because we're talking about the fee schedules.
Right,
Is that in this, are you talking about the fee schedules?
I am talking about fee schedules, and I'm talking about additional sections of the code being charged $500. And I'm clarifying what the definition of this section is. So if we look at, just take any ordinance, but.
Polly, just understand, this is 64.2?
Yes,
Okay, we haven't even talked about it yet.
I know, I'm just using it as an example.
Okay,
That is section 64.2, and it has all these sub parts to it.
okay.
So my question is, when you're talking about an additional section, is it these subparts, or is it a different number like section 65?
It would be anything that doesn't fall under 64-2 or 64-3. So all those subparts are all the same part of the same section. So when you quote when somebody asks you for a section of the code, you tell them the chapter, the article, the section number, which tells you, and if there are subsections. So say for the RMM, which is 64-2, and you want to talk about prohibited uses being commercial uses, you would say section 64-2, which is chapter 64-2, subsection C, subsection 1.
Right, so I'm just clarifying that
So
anything in that 64.2 section would be one variance.
Correct.
Under what you're proposing. Okay, that's what I wanted to clarify and make sure. I agree with Ken, I think the $500 is a little steep. But that's all the comments I have. Thank you.
Thank you very much.
Mr. Chairman?
Yeah.
I think in general, I'm very much in favor of simplification.
Yes.
Simple is smart. And I think we tend to overcomplicate things. And so if we could overall step back and take a look at this and see what, I put myself in the shoes of an applicant asking for variance. There's no way for them to determine upfront how many of the sections, subsection, or supersections are going to, so there's no way to determine what the cost of the thing is. So I know there are, small fees for $25, but let's keep in mind that keeping it simple will probably relieve the staff from a lot of work and save both the town and the residents a lot of money. So I personally think that that's a metric that we should keep in mind as we go through this, is keeping this stuff as simple as possible. Thank you.
Sure. And that's what I think you're in essence still trying to do, and I think
Yes.
that's important. So I did like Mark's comment, it's 1,500, maybe there's another set number that if there's multiple pieces of it. So, but can you clean this up for us, show it to us next time. Let us look at it at that point, right?
And think about those matters that can be done administratively
Yes.
as opposed to.
Yes. Please. Okay, moving on, correction of section 64.2. Christie?
Yes, Mr. Chairman, this is just a cleanup item. What we had found through looking at the RMM section of the code 64-2, it made a reference back to single-family development in 64-1. When changes were made to 64-1, those changes weren't repeated down in 64-2. So what you have is a situation where you build a single-family home in RMM, you don't have development standards. So it came up a couple times recently, and we said, oh, we need to make this cleanup. Basically, it was a 2005 ordinance that made changes to 64-1 and then didn't carry those down to 64-2. So the highlighted provision in the code changes it to include what's all required for 64-1 regarding single-family development if you're developing a single-family home in RMM. So it's just a cleanup item.
Okay, move to approve.
Yes.
Seconded.
Yeah. All in favor?
Aye.
Okay. Okay, great. Last thing, so the surtax, is there anything for us to do here?
That's the next, that we have to close.
You have to close and do that? Okay.
So can we have just a couple of commission comments?
Yes.
We can close this meeting.
Let's,
Here. Real briefly.
Yep.
One is, I noticed in last month's meeting, you talked about accessory structures and things like that. And there was some confusion from the looks of it. I'm looking for the minutes, I'm sorry. And just by way of background, and nothing ever happened, discuss possibility to allow outdoor spaces, accessory structures, et cetera, pergolas within the setbacks. This is part of, there's a consensus in there, and back to the town commission recommended that and remain with the Board of Adjustment. So I think, maybe I obviously wasn't here at that meeting, so I don't know the entirety of that discussion. But I want to make sure that we, at some point in time, I think it's in conjunction with the concept of encouraging single-family, single-story residences. So I want to make sure that we're bringing this back to discuss those things of advantages for single-story residents. And was that part of that discussion at all? Does anybody recall?
I don't.
no,
Okay,
not really, because
so-
what we had been provided is the, what had been proposed in Gulfstream.
Okay,
And starting to look at, I think what the comment that I heard was, let's look at what they're doing. Some commissioners asked us to do that as well. Can you look at what they're doing? And let's start to get some ideas together for that.
okay. So as part of that, I think before you send it back to the commission, regroup and talk about that a little bit more, because I think we can. And do that in conjunction with the overall massing for the properties, and to try to do things and come up with ideas to encourage single-story residences, and just give some little advantages to having a single-story residence and reducing the overall massing. Otherwise, we're just gonna be another, just nothing but a town of 12 homes or more. So I'd like to bring that back. So that's one comment. The second comment is, Christie, it's more of a question maybe, is did we, I know when we corrected all the properties on Anna Street South, and that by virtue of that code section, did we handle all the other legal non-conforming lots in town, or we didn't address that? I thought we talked about that, but did we address the rest of them?
No,
Okay.
it was specific to those on Old Ocean between Anna and Corinne.
Yeah.
Yeah, yeah.
I think we need to probably take a look at that and bring it back, and then address any other non-conforming legal lots, so that we can put this stuff to bed once and for all. Do you have a problem with bringing that back to us? I'm looking at the other, for example,
Could you
there's.
be a little bit more specific?
Yeah,
Because
sure,
we got-
there's a few lots along in the estate district, that are legal non-conforming lots that are 50 yards or 50 feet or 75 feet. They're small, and we've never really dealt with that. And if we didn't, I couldn't recall if we did or not, but I think we should take a look at those and resolve it. And some of this came up with looking at some of the small lots, and I guess we've kind of piecemeal tackle it. You know, the south end, what was interesting is Lot 8 and Sable was a small lot compared to all the other lots in that subdivision. And so some of this started to think about, that we have a lot of small lots that we have to address because they're legal non-conforming lots. So,
They may be illegal, non-conforming.
they might be, yeah, right. But, yeah, so we want to, like we did before, we want to make them legal so that it's not an issue going forward and address some of these things that happened in the past. We have to deal with it, so.
So maybe should we just start with looking at the single-family estate, those lots?
Yeah, I mean, start with there.
Start
Yeah, that's probably most of them anyway, so.
Where is that? We're just.
Just south of Ocean Avenue. You'll see just before Anna Street and before the.
Oh, up toward the
Ocean.
ocean, that little
Yeah,
side street
right.
next to the big
Right,
houses, yeah.
right. Edith Street, that
Yeah, yeah.
area.
Good. Okay, any other comments? Thank you,
Yes.
Ken.
You brought up the noise ordinance that exists in Palm Beach.
Leaf blower?
Leaf blower. Well, no, it's decibels, so I don't think it's restricted to that particular piece of equipment. Does that fall under planning and zoning, or?
It's certainly something we can discuss and bring a recommendation to, I would think, the commission.
Yeah, I'd like to add that for future discussion.
Okay.
Yeah, that's the way of the future.
We can make Monday the lawn mowing day.
Has the,
Perfect.
That's Saturday night?
Like, we don't share any.
Carolyn, have the commissioners ever talked about the noise ordinance?
That's not true. We have, they haven't.
Okay,
We have in the past.
Yeah.
And dealing with decibels is very difficult because you have to have it at the time and, you know, there's all sorts of things there. So, it's somewhat difficult dealing with those issues. I can tell you can talk to the chief about that. Trying to enforce that is very, very, very difficult. So we have had, at a commission level, we've had talked about that in the past. This, what I think is a little different, because they just, I think they didn't deal with decibels. I think they just banned certain
Gas
things.
powered.
And
I think Gulfstream did.
Gulfstream did? All right.
Yes.
So, you know, those are the things you look at, because they're annoying.
Yeah.
Kind of falls in the category.
Lynn, can you
of,
look at what has been done? Just give us a little color on that. That'd be great. Great. Anything else, Mark?
No, sir.
Neil, guys, gentlemen? Nothing. Okay. No, yeah, it is a good point. Okay. Hearing no more, let's adjourn the meeting. Okay? Move. Everyone in favor?
Aye.
Okay, great.
Oh, the new order.
Huh?
New order.
New order. The Infrastructure Surtax Oversight Committee, regular meeting. Like to open the meeting, February 18th, 2025, Town of Ocean Ridge Infrastructure Surtax Citizen Oversight Committee. So I'll call the order. Roll call.
Member Perrella,
Present.
Member Duffy,
Mark?
Yes.
Member Siggety,
Present.
Vice Chair Khalil,
Here.
and Chair Berger.
Here. Okay, first being asked to look at the minutes.
Move to adopt the minutes of February 20th.
Okay? All in favor?
Aye.
Aye.
Who seconded it?
I second.
All in favor?
Aye.
Aye.
Okay. Action, approve the report to the town commission regarding infrastructure surtax 2024.
All right, in For FY '24, the town received $152,903.81 from the infrastructure surtax. That brought our total to $1,077,575.91. As was discussed at the meeting in early '23, at the end of FY '24, or of FY '23, the Infrastructure Surtax Committee had recommended trying to save $500,000 for other projects and leaving the remainder discretionary for the commission. The commission did take that into consideration, but with the additional costs that needed to be spent for the water main line on the north end of town, we were not anticipating it ending up being a 2.3 bid project, 2.9 constructed project. The commission authorized using all of the infrastructure surtax funds for that project. There is one more, I believe, partial year of surtax funds that will be coming in. The surtax is anticipated to expire in around August of 2025. That is due to the fact that they will have reached the cap that was in the voter-approved referendum, as opposed to having reached the end of the term. So we will most likely only have one more these meetings. After that has capped out. And at that point, the county and the other jurisdictions have not moved forward with putting a renewal of the infrastructure surtax on the ballot. So it will simply expire and at that point, no longer exist.
And so the balance today is zero?
The balance today is zero.
I mean, we're gonna be out of a job.
We're gonna be out of a job, yeah. What are you asking us to do then? What are you being asked to do here?
It's just making a
Accept
report
it.
to you
We're
and
gonna get 8
everything.
months severance.
Yeah.
I got candy on the desk. There you go.
Is there a motion to
Accept the report.
accept the report?
So be it. So moved.
Second,
Second.
all in favor?
Aye.
So our
Thank you.
sales tax is gonna go down?
Yeah, right.
Adjourn, we'll look to
That's a
adjourn the
message.
surtax meeting. Thank you.
Thank you, gentlemen.
Thank you, good job. Oh,
Thank you.
I would
The
tell you that the
tax
school
dying.
district did get their operations, I think it was an operations sales tax through in the last election. So while you won't see the infrastructure surtax, the school surtax
Bigger.
will be coming on
Yeah.
in its replacement.
No tax will be behind before being
Okay,
replaced by a
thank you.
bigger one.
Thank you, everyone.
Thank you.
Appreciate it. Appreciate your